All right, let's talk about something that's a huge deal for anyone working in Switzerland, but is also, let's be honest, a total mystery to a lot of us. I'm talking about the work certificate, the Arbeitszeugnis. And trust me, it is so much more than just a piece of paper.
So, when you get your certificate, what is it really saying? Is it just a simple summary of your job, or is it one of those carefully worded puzzles, filled with hidden meanings? Well, today, we're going to unpack the legal tightrope that employers have to walk, and most importantly, what it all means for you and your career.
Okay, so at its core, the Arbeitszeugnis is a legally required document. It's supposed to summarize your job. Simple enough, right? Well, not exactly. Here's the catch, and it's a big one. The law basically says this document has to serve two masters at the same time. And that one little detail, it's the source of almost all the drama and confusion we're about to get into. So here's what we're going to cover. First, that double duty I just mentioned. Then, the 4 big rules for fairness. We'll dive into some tricky situations, decode all that fine print, and finish up with what you can actually do about it, your rights. All right, let's jump right into that core conflict. I mean, what are these two goals that are always pulling in opposite directions? It's a real balancing act, for sure. And here it is, the central tension in a nutshell. On one side, the certificate has to be, well, nice. It's supposed to help you get your next job. But on the other side, it has to be brutally honest for the next company that's thinking of hiring you. And this constant tug of war, if you get this, you'll get everything else we're about to talk about. Okay, so how do you manage a conflict like that? Well, the Swiss courts have basically laid out the rules of the game. They've established 4 key principles, 4 pillars really, that every single certificate has to follow. This is the yardstick they're all measured against. And this really captures that conflict perfectly. You've got the duty of truth, the Wahrheitspflicht, which the courts say is number 1, it has to be factually correct. But right on its heels is benevolence, Wohlwollen, which says, okay, be truthful, but you have to frame it in a way that doesn't torpedo someone's entire career for no good reason. So you have truthful, clear, complete, and benevolent. The big thing to remember here is that these aren't just 4 separate rules. They all work together, like a system. I mean, a certificate can't be benevolent if it's super vague, right? And it can't be truthful if it leaves out a huge piece of the story. They all have to be in balance. So, what happens when the truth isn't exactly nice? When being honest could really hurt someone's job prospects? This is where it gets really interesting. Let's dig into some actual court cases. Okay, this is a big one. A question I'm sure a lot of you have thought about. Can your employer mention that you were sick? And look, it's a totally valid concern. The answer, though, isn't a simple yes or no. It all hangs on one critical factor. It's all about context. It's about painting a true picture of your experience. Think about it. A couple of weeks off sick over 5 years? That's totally irrelevant. But what if someone was out for a really long time? If you don't mention that, it could give a totally false impression of how much hands-on work they actually did. Check this out. This is a real case. A teacher was on sick leave for about 10 months. Now, the court ordered that sentence removed from her certificate. Why? Because she'd worked there for 7 years. So in the grand scheme of her entire employment, the court decided that 10 months wasn't significant enough to risk damaging her future career. It's all about that balance. And this brings us right back to that pillar of clarity. See, just like leaving something out can be misleading, putting something in that's super vague is also a big no-no. Your boss can't just hint that there were issues. They have to be specific and fair, or just say nothing. Vague, negative comments are a huge red flag for the courts. Here's another great example. A court threw this sentence out entirely. Why? Because think about it from the next employer's perspective. What on earth does irregularities mean? Did the guy embezzle 1,000,000 francs, or did he forget to log his lunch break? It's completely useless and unfair because it's so vague, so it had to go. All right, so it's not all about the big, dramatic stuff like illness. The little details, the fine print, oh yeah, that matters just as much. Let's zoom in a bit and talk about things like secret codes and even who signs the thing. So these so-called secret codes are totally forbidden. But it's not just about obvious codes. The courts are also cracking down on language that's just a little too clever, a little too open to a negative spin. For example, a court actually removed the sentence, "She was keen on fair discussions." Sounds okay, right? But the court said, nope, that could be interpreted to mean she was argumentative.
It's not clear, so it fails the test. And believe it or not, even the signature is a big deal. It has to be signed by someone higher up the chain than you. Your direct boss is perfect. It can't be a colleague and definitely not someone junior to you. That's considered insulting. And it has to be a real pen-on-paper signature from someone inside the company, not some outside HR firm. What about those nice little phrases at the end, like, we regret their departure or we wish them all the best? A lot of people wonder about this. And the answer is, while they're great to have, you can't legally force your boss to write them. The courts have said you can't sue someone to make them express an emotion. So, and this is important, if those words are missing, don't just assume it's a secret negative code. Okay, let's get to the really important stuff. What can you actually do if you get a certificate and you think, hang on, this isn't fair or this isn't even true? This is where the rubber meets the road. Knowing your rights is, without a doubt, your most powerful tool. First off, you have a choice. You don't have to get the full detailed certificate. If things ended on a bad note and you're worried about what they might write, you have the absolute right to just ask for a simple confirmation. It just says what your job was and how long you were there. No performance review, no drama. And get this, you have 10 years, a full decade. That's a huge deal. A major court ruling confirmed it. You have 10 years to ask for a certificate or to get one corrected. So even if you don't spot a problem right away, you're not out of time. That's a pretty powerful safety net. And this brings everything full circle back to why that duty of truth is so important for employers. Let's say your old boss writes you a glowing reference, hiding some really big problems. If your new boss hires you based on that and then suffers because of it, they can actually sue your old boss for damages. It doesn't happen often, but that risk is what keeps companies honest. So, what's the big takeaway here? Your work certificate is always walking this tightrope between being kind to you and being truthful to the next person. To really understand it, you have to see that balancing act. It's not just about the words themselves, but about the legal rules pulling them in different directions. So now, I've got a question for you. Go pull out your last certificate. Is it just an accurate reflection, or is there a hidden message hiding between the lines?